enjoyed your lunch. Anything to address before we bring in the jury?
So, Judge, it's my understanding that we're bringing everyone back in, right? So I would just say, juror number 23, she's been caused, but she was the one that has like the severe anxiety. Just for her sake, given she was said that even just talking about the charge gave her anxiety, I would be okay releasing her. But I'm just bringing that up. I'll defer to the court, but I just feel, given that was the reason for the cause.
Anyone else?
No. Agreed.
So that's the only one you want to release now?
Yes.
Deputy, could you bring in 23?
Did we? And sorry, juror 60, who we all know.
Oh, and juror 60. 60. Yes. So you all don't have to come all the way in. I just wanted to let you both know that you've been excused from further service. Please go down to the jury office. Let the jury office know that you've been excused so nobody's looking for you later. Please go directly to the jury office and don't talk to any of your fellow colleagues that are still on the panel. And you have the court's profound thanks. Deputy, once those jurors are close to the elevator, we can bring everyone else in. Thank you, sir. Mr. Williams, you okay, sir?
Yeah, I appreciate you asking.
All right, we're going to bring in the jury now. I'm going to ask some questions, okay?
Okay.
Counsel, could you approach? Please be seated. I hope you all enjoyed your lunch. All right, silent. Do we have food? Anybody with gonna get tired because of a food coma? We're gonna be okay? All right. So now I'm gonna go over what I call some constitutional concepts. These are concepts that I want to discuss with you to make sure you understand your role as jurors and to make sure that with these constitutional concepts, you're going to be able to do your job as jurors in this case. So before I do that, I want to tell you Mr. Williams is charged with first-degree murder with a weapon. Mr. Williams is presumed innocent. As he sits here today, he is innocent. Does everyone understand that? He has a constitutional presumption of innocence. Does everyone understand that? Does anyone not understand that? Raise your paddle. So just to make sure that these constitutional concepts are resonating and that I make sure that you're understanding them, I may ask for some participation. You can raise your paddles and volunteer to participate, or I can, what they call, voluntold you to participate. So it's more helpful if you volunteer to participate, but if not, I may pick on you, and I'm not picking on you to pick on you. I'm just picking on you to make sure that we understand these constitutional concepts, okay? So I'll first pick on someone just to make sure. Juror 14. Raise your paddle. The deputy's going to get a mic to you. Do you have the mic? Oh, she's getting it.
Hello.
Hello. So if I were to give you a verdict form right now, and you were to choose Mr. Williams guilty or not guilty, what would your verdict be?
Completely innocent. Not guilty.
And that's because?
I know nothing of him other than he sits there. So
And he is?
Innocent before.
Presumed innocent. Does
Presumed
everyone
innocent.
understand that? Does anyone not understand that? Raise your hand. If I gave each of you a verdict form right now and asked you to complete your verdict form would be not guilty because Mr. Williams is presumed innocent. Does everyone understand that? Is anyone going to fill out the verdict form and put guilty? Please raise your paddle. Seeing no hands raised, I'll move on. Mr. Williams has the constitutional right to remain silent. That's his Fifth Amendment right. That means he does not have to testify in his defense. Does everyone understand that? All right, we're all human. Some of us are managers, parents, or the like, and we like to hear from both sides in order to make a reasonable decision. Our Constitution does not afford that here in these proceedings. The state has to prove each and every element of the charged crime. Mr. Williams does not have to prove anything. He does not have to disprove anything. Does everyone understand that? This is really important, so I'm going to continue on with this topic. Some of you may go into the jury room and be undecided and say, you know what? If Mr. Williams had only testified, I would check not guilty. We need to know now if you are going to go back into that jury room, if you are selected, and decide this case based on whether or not Mr. Williams testified. Is anyone going to go back there and do that? Seeing no hands raised, I'll move forward. As I said just a minute ago, the state has the burden of proof. Not some of it, not most of it, all of it. They have to prove each and every element of the charged crime beyond and to the exclusion of every reasonable doubt. Does everyone understand that? Does anyone not understand that? Raise your paddle. Miss Wilson, Miss Gasgery, Mr. Williams can sit there, do crossword puzzles, play Candy Crush, turn their backs, read a newspaper, do whatever, and you cannot hold it against them because they do not have any burden to prove or disprove anything. Does everyone understand that? I promise you they won't do that, but our Constitution affords them the opportunity to do that, and you cannot hold it against them. Does everyone understand that? Is anyone going to expect the defense to do something in this case to disprove what the state is seeking to prove? Raise your paddle, please. Seeing no hands raised, I'll continue. You are the judge of the facts. You decide what the facts are and what the facts mean. You are judges just like I am. I'm the judge of the law. You're the judge of the facts. So I want to take this opportunity now to explore with you what you'd be looking for when determining the believability, credibility, or reliability of any evidence in this case while you're doing your jobs. This is one of those opportunities where you can participate or I can ask you to participate. So if someone raised their paddles as to what you would be looking for when determining the believability, credibility, or reliability of any evidence that the state brings forth in this case. Juror 40, thank you for raising your paddle. Let's get a mic to you.
I would say fingerprints or video evidence.
Okay, so you want something tangible, I'm hearing you say?
Yes.
Okay, thank you. Juror 40 is looking for something physical, something tangible. What else would, or if it's just that, I want to engage in a discussion. What would you all be looking for to determine the believability, credibility, or reliability of any evidence in this case? Juror 54. We'll get to Juror 10 in a minute, but we'll go to 54. All right, thank you, sir. We'll get a mic to you just so that you can be on hold. Juror 54, do you have a mic? Not yet. Sir, what would you be looking for when determining the believability, credibility, or reliability of any evidence in this case?
I would say more so things like timestamps, whereabouts, things you're able to use in terms of documentation as to where the person was, what time, in terms of relation of everything, and be able to use that to piece things together as well.
I'm hearing you say like electronic evidence. Am I encapsulating that correctly?
I would say around that, yeah, just to be able to use that, yeah, as well.
Okay, thank you. Juror 10.
I would say looking for eyewitnesses.
You want to hear some eyewitness testimony? Yes?
Yes.
Expound upon that, if you would, please. What are you looking for when you're seeking this eyewitness testimony?
If someone was in the area and saw what was going on, or even to the fact of maybe like a camera.
Adding a little bit to the context, potentially saying he didn't say it, but I'm just adding to it that he's not going to follow it because he thought it should be part of it. And so it doesn't matter if you think it should be part of the law, it's whether you're going to follow the law. Does everyone understand that? And you may not like the law, but you still have to follow it. Does everyone understand that? Is anyone here not going to follow the instructions that I give you at the end of the case? Raise your paddle. Even if you don't like it. Is anyone not going to follow the law? All right, thank you, Juror 6. Could you pass it behind you to Juror 16?
DNA.
Okay, you're looking for DNA evidence. Thank you. Anyone else? We got 48, 57, and 55.
I'd say like an expert providing testimony.
right, thank you. An expert. I think it's 57 and 55.
Does he have criminal history, the defendant? I mean, would that be considered?
Well,
as
you're
a
going to get the
pattern?
evidence in this case. What if you don't get an evidence of criminal history? Are you going to be in the back of your mind wondering that?
No. If there's no, I mean, if the defendant has never even received a speeding ticket.
What if you don't hear that evidence? Are you going to have that
No.
in the back of your mind saying, I wish somebody would have told me that? I'm sorry, say it again. I didn't hear you.
I don't know. It's first time I get picked.
I understand that. And that's why I'm asking you, because we're trying to determine whether or not you can be fair and impartial. So we're trying to make sure and understand if you're going to bring anything outside of what you hear and see in this courtroom in your determination. Now, you all have life experiences, and we're not telling you not to bring your life experiences, but we just want to make sure that when you determine what the facts are and what the facts mean, it's going to be based on what you see and hear here.
I understand.
Okay.
Making a decision based on the facts are provided to us.
Right. So I'm going to follow up with that. If you don't hear any evidence of any history, is that going to factor into your determination
No.
as to whether the state
No.
met their burden?
No, it will not.
Thank you, sir. You're 57? 55?
I'm not sure, but if the defendant had confessed already, when he was interrogated, if the defendant had confessed to the crime.
Are you asking me or are you telling me?
I'm telling you that, because that's part
Okay,
of what
don't
they will
hold
show
up,
us.
hold up. Can you approach, please? Can you come up to the bench,
Sure.
counsel? So I just wanted to clarify whether or not there's any, as you know, there's some publicity about this case. So I wanted to make sure about that. So I'm going to ask Juror 55 to restate what you said.
I guess what I'm saying is if the defendant was caught in the act and had confessed to it.
What if you don't see any evidence of that? Would you wonder in the back of your mind as to whether or not there was some confession?
No, because I'm only going to look at what they present to me.
All right. Thank you. Anyone
Sure.
else? 51. If you pass the mic to 51. Yes, sir.
Yeah, I'd definitely say any sort of blood or DNA for sure.
All right.
I mean,
you're,
that's a telltale sign. If
you're like
it's-
juror 16. You're looking for some CSI evidence?
Well, if the person's not tangentially connected, but you find like blood or something like that on an object, it's kind of telling.
All right. I appreciate that. 59.
Yes, thank you.
Do you have the mic? Okay. Could you speak closer? Yep. Just
Okay.
put the mic a little closer.
Right. Earlier, you explained that you're the technical judge of this case.
I'm the
If-
judge of the law. You're the
The
judge,
judge
of
of
facts.
the law. Correct.
Yes.
That's what I meant to say. So, can you explain a little bit more, because that raised a question to my mind and said, okay, what are we looking at in this case? Can you explain to us what we're looking at in this process that we're going to go through? The type of case it is. You said that there is no witness, and then that this is not a witness-based case.
I
That's
didn't
new
s-
for me.
I don't think I'm pretty sure I didn't say that there's no witnesses. I'm using hypotheticals at this point. Ms.
Oh.
Walensky identified certain witnesses that she intends as a representative of the state to call.
Right.
I'm an open vessel as well, so to speak, because they're going to be the ones, they being the state, is going to be the ones presenting the evidence.
Okay.
I'm not presenting anything
in,
other than the instructions on the law.
Right. In that case, I misinterpreted you then.
In that case, what, sir?
I misinterpret to you.
You misinterpreted. Okay. I apologize if I misspoke and that's caused you to misinterpret.
That's fine. Thank you.
Anyone else? 53 and then 32. Yes, ma'am. Well, how this process will work is the state, because they have the burden, will present evidence to you. Evidence will be in the form of people, individuals, maybe eyewitnesses who are going to testify, and that'll be evidence from them. And then there may also be tangible evidence, documents, videos, things like that. And based on the evidence the state presents to you, you decide what the facts are, what the facts mean, and whether the state has met each and every element of the charged crime beyond and to the exclusion of every reasonable doubt. Does that answer your question? Thank you. I forgot the other 32.
No, oh, wait. Hi, I'm sorry. I think you kind of explained what I was gonna say, but basically what I'm expecting is to see a chain of events and, narrated by the evidence. That's pretty much what I was gonna say.
All right, I appreciate that. I think that's similar to what Juror 6 said, which is context, right? Is that kind of what you're looking for, sir? Okay. 35?
Thank you, Your Honor. I'd like to go back to the question about if there's prior criminal history, are we allowed to consider that as evidence?
You can only consider the evidence that's elicited in this case. So if
Okay,
there's
so
no
nothing prior.
evidence of criminal history,
But if there were evidence of criminal history from prior convictions or anything like that?
you consider whatever the evidence is in this case.
Thank you.
That's the best answer I can give you. And as jurors of the facts, judges of the facts, you can believe, disbelieve, some, all, or part of the evidence that's presented. So you can believe, disbelieve some part of or all of testimony of a witness or the documentary evidence that's presented to you, because that's your role, your power as a juror. Okay? Does everyone understand that? Does anyone not understand that? Anyone else want to contribute to the discussion of what you would consider when determining the believability, credibility, or reliability of any evidence in this case? Seeing no hands raised, I'll move on. Someone mentioned experts. I forget who, someone on this side mentioned 48, mentioned experts. So I want to talk a little bit about experts and witnesses. There are two types of witnesses that'll testify in a case: experts and lay witnesses. When I was when I was a lawyer before I became blessed on the bench, I was in civil. I did civil defense, and I'm going to use an example: a car accident. If there's a car accident and the car is damaged, a mechanic may testify. Mechanics know what the damage is, how to fix it, sometimes even how it happened. That's an expert. Does everyone kind of understand that? Yes. Does anyone not understand that? Raise your paddle. All right. And then there's lay witnesses, people that are going to testify about what they see, what they saw, depending on the context, what they heard and observed. Those are lay witnesses. Does everyone understand that? Does anyone not understand that? Raise your paddle. As you heard Ms. Walensky go through the list, some of those witnesses are members of law enforcement. Law enforcement are not experts. Does everyone understand that? Or if you didn't know that, now you know. Are you able to accept that? They are not to be given any more credibility because they wear a badge and a uniform, and they're not to be given any less credibility because they wear a badge and a uniform. Does everyone understand that? Does anyone not understand that? Raise your paddle. Because people have encounters with law enforcement, I want to delve into this topic. I want to identify whether anyone here has strong feelings because of your prior experience or encounters with law enforcement that will affect your ability to assess the credibility, believability, or reliability of their testimony, okay? So I'm going to go row by row and ask you this question. Does anyone have any strong feelings concerning law enforcement? Raise your hand. Then I'm going to ask you another follow-up question. Is it strong feelings for or against law enforcement? And to define that a little further, what I mean is strong feelings for means that because they wear a badge and a uniform, they come with a level of credibility and you're going to start believing what they say just because they're members of law enforcement. That's strong feelings for. Then the other category would be strong feelings against. Just because they wear a badge and a uniform, I don't believe anything they say. Does everyone understand? Does anyone not understand? So I'm going to go row by row and ask each row to raise your hand if you have strong feelings concerning law enforcement, and then I'll follow up with the other two questions, okay? Row 1. Anyone in row 1 have strong feelings concerning law enforcement? Please raise your hand. Paddle. Juror 7. Juror 7, is it strong feelings for or against? Thank you. Juror 10. Strong feelings for or against? Thank you. Anyone else in row Juror 3? Strong feelings for or against? Thank you. We need to get a mic to you, but you've answered my question. The attorneys may have some follow-up questions for you. Okay, sir? Thank you. Juror 4? Can we get a mic to Juror 4? Please.
Overall, it's for them, but I do have against them too.
All right, so you're kind of in the middle.
Pretty
As
much.
the kids go 6-7, 6-7, right?
I'll go towards against then.
Pardon me?
I'll go against.
All right. Juror 1, did you raise your hand? For or against?
Yeah, because
For or against, ma'am?
sure. But my problem is my English.
Okay.
My English is no good now.
Okay.
No, not yet. I am study, but I don't understand all. Sorry.
Thank you for letting us know. Anyone else in row 1? Row 2. Strong feelings concerning law enforcement. Juror 16, let's get a mic to you.
4.
4, thank you, ma'am. Anyone else in row 2? Row 3. Juror 20, is that 27? Juror 27. 4. Thank you. I think juror 25.
4.
Anyone else? Juror 22.
4.
Anyone else in row 3? Row 4. Juror 31. 4 against.
I'm sort of in the middle.
Then it's neither for nor against, and that would be good.
Yeah.
You're in
I
the
have
middle?
some reservations, yeah.
Pardon me?
I do have some reservations, yes.
You have reservations concerning law enforcement?
Yes.
Thank you. Juror 36. For or against?
4.
Thank you. Juror 37. For or against?
4.
Thank you. Juror 38. For or against?
4.
Anyone else? Yeah, I heard. Are you raising your paddle 40?
Yes.
For or against?
Against.
Thank
I
you.
explained my history.
No explanation right now. Just needed those 2 questions answered. Thank you, sir. Juror, row 5. 45. For or against?
4.
Thank you. Anyone else in row 5? Row 6. All right. Seeing no paddles raised, I'll move on. The last thing I want to do now, before we begin to select the jury, is to explain to you how the process works. This is the part of the case where the parties and the attorneys have an opportunity to get to know a little bit about you in order to help them come to their own conclusions about your ability to be fair and impartial, so they can decide who they think should be jurors in this case. How we go about it is as follows. First, well, I've already asked you those questions in the questionnaire, so I won't ask you any more questions other than the ones I've already asked. The The lawyers will ask some specific questions of you. After they have asked all of their questions, I will meet with them and they will tell me their choices for jurors. Each side can ask that I exclude a person from serving on the jury if they can give me a reason to believe that that juror may be unable to be fair or impartial. That is what's called a challenge for cause. The parties also have a number of peremptory challenges by which they can excuse a juror. By this process of elimination, the remaining persons are selected as the jury. It may take more than one conference among the parties, the attorneys, and me before those selections are made. The questions that will be asked of you during this process is not intended to embarrass you or unnecessarily pry into your personal affairs, but it is important that the parties and the attorneys know enough about you to make this very important decision. If a question is asked of you that you would prefer not to answer in front of the whole courtroom, please just let us know, and you can come to the bench with the attorneys. The rest of you will hear this, which you've already probably heard. There are 2 mics. The court reporter is here, so we can still capture what is being said, but the rest of you will not hear anything. If you have a question of either the attorneys or me, please do not hesitate to ask. There are no right or wrong answers to the questions that will be asked of you. The only thing I ask is that you answer the questions as frankly, as honestly, and as completely as you can. You have taken an oath to answer all questions truthfully and completely, and you must do so. Remaining silent when you have information you should disclose is a violation of your oath as well. If a juror violates this oath, it not only may result in having to try the case all over again, but it could result in civil and criminal penalties against the juror personally. So again, it is very important that you be as honest, as complete, and frank with your answers as you possibly can. If you don't understand a question, please raise your paddle and ask for an explanation or clarification. In sum, this is a process to assist the parties and the attorneys to select a fair and impartial jury. All of the questions that will be asked of you are for that purpose. If for any reason you do not feel you can be fair or impartial, you must tell us. Each side has equal time. The state has the burden. With the burden, they start first. Ms. Walensky, do you wish to inquire?
Good afternoon. Oh, man. I have the unenviable task of talking to you after lunch. I know everyone is tired, and it's already been a long day, so I'm going to do my best to be quick, keep you awake, and get us through this process, okay? Now, I'm sure you can already tell by how long this has taken so far that jury selection is a really important process. And the reason why it's so important is because it's the only time that we as attorneys get to talk to you. Once the jury is selected and the jury moves to the much more comfortable chairs, we do a lot of talking at you. We can't stop and ask you if you have a life experience that makes a certain fact hard to hear, or if something in your past has made it so you can't be fair. So this is our only time to do that. So I ask that you bear with us. I'm going to try to do this as quickly as possible. We're going to talk about some concepts, and it's going to seem a little bit weird because even though the judge read to you that little blurb about the case, we don't talk about the facts of the case up here. We just talk about concepts. So it might seem unusual. Some of the questions might seem odd, but just bear with us. There's a method to the madness. And also, I'm going to ask you some questions about answers you've already given. Now, since you wrote those answers, we don't know what you're comfortable talking about and what you're not comfortable talking about in front of the group. So if I ask you a question from the questionnaire that you filled out, if it's something you're not comfortable talking about, just let us know and we'll make a semi-private situation for you. With that, the other thing by way of introduction, I want to let you know, I'm sure you heard the instruction from the judge this morning that all of you had to turn all of your electronics off. And then we're sitting up here, myself and Mr. Clossy, with our computers, with our phones. We are abiding by the court's orders. It's our responsibility to present this case to you to make this go as smoothly as possible. So if you see us on our phones or on our computers. We are engaged in this process. We are not checking social media. We are actively engaging with our office to make sure this process moves smoothly for you. So with that, if we could go to juror number 1, we can get a microphone to juror number 1. Good afternoon.
Good afternoon.
So you just mentioned to us that you were having some trouble understanding.
Yeah, I studied for the last 5 years in adult class, but my English, I feeling is not good for this case. I don't understand all the terms. For me, it's very difficult. The English is difficult now.
All day today, since you've been in this courtroom, have you understood everything we've said?
I'm sorry?
Have you understood everything that we've said in the courtroom today?
No.
Okay. About
No.
how much would you say you've understood?
The continuum, my English is no fluency.
Okay.
Yeah, is I understand the words in the house, in the shop, and other, but for the terms legally, is no understand all. Yes, I'm sorry.
Okay. Thank you very much.
Yeah.
If you could pass that microphone back to you to juror number 11. Microphone's coming to you. I'm going to try to keep it so you guys aren't throwing the microphone all over the room. Good afternoon.
Hi.
Okay. So I want to talk about some concepts. And when we're talking about concepts, I'm going to kind of give everybody information, and then you'll hear that by the end, I bet you'll be able to tell me my questions because you'll hear them so many times. So just hold on to the microphone. I'll talk to everybody, and then I'll come talk to you about it, okay? So one of the things that the state has to prove in this case is that the crime was premeditated, okay? So many of you might have come into this courtroom with an idea of what you think premeditation means. I'm going to read to you the definition of premeditation, and then we're going to talk about it, okay? So killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. Okay, so juror number 11, you still have the microphone?
Yes.
Okay, it's a lot of words, right? Let me see if I can get somewhere where I can see you. So did you come into court with an idea of what you thought premeditation meant?
Yes.
Okay. Did you think it meant that we had to prove that somebody planned to do something?
Yes.
Okay. Now, I know I said a lot of words there, but none of those were planned, right?
Right. Just that it occurred, or the thought was there before.
Before the killing.
Yes.
Right. And there's no fixed period of time, no amount of time that the person has to think about it, just that we prove that they did.
What the attorneys say is not evidence or instructions on the law. Instructions on the law will come from the court at the end of the case. You may proceed.
So knowing that we don't have to prove a plan, or we don't have to prove a specific amount of time that somebody thought about it, just that they had that time for reflection. Can you follow that law?
Yes, I think. Yeah.
Okay. So you're not going to require us to prove something that's, what we're really trying to find out is, are you going to require us to prove something that the law doesn't say we have to prove? Like a plan, or that somebody thought about it for X amount of time?
I wouldn't say thought about it for a certain period of time, but that they had thought about it in advance of actually taking an action.
Okay, and that's really what it says, right? That's what the law says. So, do you think that people can make big, life-altering decisions quickly?
sometimes.
Okay. Even if it's a decision you might not make, can you accept the fact that somebody might make a decision that you might not necessarily make quickly?
Yes, but I guess it depends on somebody's even, state of mind.
Of course, right? That's what
Right.
we're talking about, right?
Mhm.
And on that note, talking about state of mind, we don't really live in a society where people kind of walk around and announce what they're going to do, right? I've been doing a lot of things while I've been standing up here. I've been walking around. I've picked up my pen a couple times, but I haven't announced what I was going to do. I've just been doing it. So how can you tell in a world where people don't announce, I'm picking up my pen, I'm writing this down, how can you tell that the person is acting with intent?
I guess that is what I would have to see enough evidence to support to make that decision.
Can you watch what the person is doing and how they're acting to see if the person's actions are intentional?
Maybe.
Okay. All right. Stick with me, okay? I'm gonna let you off the hook soon. I know it's hard to be first. Okay? Now, the judge touched on this a little bit, and this is for everybody, but our crimes here in Florida are broken up into what are called elements. So when you get the instructions at the end of the case, you're going to be told to prove the crime of first-degree murder. The state has to prove, and then it'll be what are called elements. The state has to prove A, B, and C. Doesn't even matter what they are right now. It will, but it doesn't right now. Okay? When you get that, what you're going to notice is that A, B, and C do not include motive. That the state does not have to prove why the crime occurred, but that the crime occurred and that it was this defendant who committed the crime. So, juror number 11, knowing that we don't have to prove the why, can you follow that? Or are you going to be requiring us to prove something that the law doesn't really require us to prove?
This kind of goes into what was going through my mind when we were talking about the evidence required. One of the things that I wasn't sure would be, it would probably be on the side of the defendant potentially to prove would be looking at like psychological background or behaviors or, things that may fall outside of that evidence. So taking factors like that into account versus, just the evidence that something did occur and it was or was not intentional.
What if it's really that black and white, though? The state has to prove A, B, and C, and we prove A, B, and C to you as a juror. But you're thinking, there's some other things you're thinking about. But the law is the state has to prove A, B, and C, and we did. Would you be able to find him guilty even if you're thinking about these other things?
I mean, I might say that someone might be guilty of committing the crime, but not that it was, again, a premeditated crime.
Well, we have to prove it, right?
Right.
We have to prove it. We always have to prove it. In any of these examples, we have to prove it. Okay, I'm done picking on you. Thank you, juror 11. Let's go to juror number 14. Microphone should be coming to you. Good afternoon.
Hello.
Okay, did you hear the definition of premeditation?
I did.
Okay. Did you come in here with an idea of what you thought that meant?
I did.
And how did the definition that was read kind of line up with
Oh,
mine?
I totally thought someone was in the garage plotting and planning and like it went on for weeks and all that stuff. I didn't recognize, made me think a lot about what you were saying to 11. Just it's thought about, it's considered it, and then it's done. It made me feel like, wow, I guess it really could be premeditated in 5 minutes, even though you said there's no duration. But like when you think about it, premeditated can be more close to right when the crime happened. But I definitely did come in here thinking premeditated was planned out, notebooks, the whole scene.
Okay. So knowing that it's different
Mhm.
and it's not exactly what you came in thinking it meant, are you able to follow the law the way it's written? The law comes from the judge. If she reads whatever she reads, are you going to be able to follow it?
Yes,
And if that doesn't include proving a plan or a fixed time period, will you be able to follow that?
definitely.
Do you think people can make big life-altering decisions quickly?
Definitely.
Okay. What about the idea that we don't have to prove why the crime occurred?
I can make a decision without the motive.
Okay, so
It's interesting. Another thing it made me think about, but I can see how I can separate those two.
okay, so if you using my A, B, and C example,
Mm.
but if the state proves A, B, and C, but at the end of the case you're left with, but I don't know why this happened. Would you be able to find him guilty not knowing that why?
Yeah.
Okay. All right. Thank you very much, Juror 14. Let's go to Juror 17. Microphone's coming to you. I was eventually going to come talk to you, right? Good afternoon.
Afternoon.
Did you come in here with an idea of what you thought premeditation meant?
So after you read the definition, it kind of opened my eyes to it. So
Okay. Can you follow that definition that we don't have to prove a plan or a fixed time period?
absolutely.
Okay. And do you think people can make big life-altering decisions quickly?
In my mind, kind of partial on that. Yes and no.
What do you mean?
So, some people can, some can't.
Of course, right? Maybe you might not, but somebody next to you would,
Yes.
right?
Yes,
Have you ever heard of somebody buying a house sight unseen?
absolutely.
That's a big life-altering decision, right? It's
Right.
different than what we're talking about here, obviously.
Understand.
But would you necessarily buy a house sight unseen?
I
It's
mean,
okay if you would.
probably I would because of the line of business I'm in. So
Okay. But do you see what I mean? That maybe the person next to you would not make that kind of big financial decision without seeing it, thinking about it, doing all those things. But maybe you would do it. You know what? I can make that decision quickly.
yes,
You see what I mean?
yes,
Okay. Do you see how it kind of, even though we're talking about something very different, how it kind of, you can analogize it with premeditation?
mm-hmm.
Okay. Is that yes?
Yes.
Okay. I understood. We just want to make sure we get everything down. How do we know what somebody's intent when they're acting, not acting like on a stage, but when they're doing things, if they don't announce what they're doing?
I guess it's just from visualization of
Okay.
the person, what they're doing.
Okay. You got to see the action.
Yes.
Do you think the actions can tell that story of somebody?
Sure.
Okay. And what about the fact that the state doesn't have to prove motive? Are you okay with that?
Yeah, I'm okay with that.
If you're left at the end of the case, the state proved A, B, and C, but you don't know why, are you going to be able to find him guilty?
Yes.
Okay. Thank you very much, Juror 17. Let's go right next to you to Juror 18. Good afternoon.
Hello.
I didn't mean to label you as the one that would buy the house sight unseen. You just happened to be next to Juror 17. Good afternoon.
Good afternoon.
Did you understand the definition of premeditation?
Yes.
Did you come in here with an idea of what you thought that meant?
Pretty much understood that, yes.
Okay. So the fact that the state doesn't have to prove a plan or a fixed time period, can you follow that?
Yes.
Okay. Do you think people can make big life-altering decisions quickly?
Happens every day. I think everything's relative to the context.
Okay. How do we know somebody's intent if they're not announcing it to us?
Again, I think relativity to the context and understanding the facts surrounding the circumstances.
Okay. And what about motive? The fact that the state doesn't have to prove motive, is that okay with you?
It is.
Okay. All right. Thank you very much, Juror 18. Let's keep everyone awake and let's bring the microphone to Juror 7. First row thought they were off the hook. Good afternoon.
Good afternoon.
So I want to talk to you about a couple things before we talk about those concepts, okay? You mentioned that you raised your paddle for having positive feelings about law enforcement.
Yeah.
Okay. So, and this is kind of, this explanation is for everybody because I'm going to talk to several of you about this. But law enforcement comes into this courtroom like any other witness, and they have to start on that same even playing field. So As soon as they open their mouths and they start talking, you're immediately allowed to start weighing their credibility. What you can't do is weigh their credibility before they start. So knowing that, are you, because you have these positive feelings about law enforcement, giving them that kind of extra credibility before they start talking? Or are you willing to wait to hear what they have to say first?
I'll listen to what they have to say.
Okay. So they are not getting a leg up from you?
No.
Okay. Now I saw in your questionnaire that you had a DUI in 2011?
Yep.
Okay. Was that here in Palm Beach County?
Nope.
Okay. Do you feel like you were treated fairly by law enforcement in the court system?
Yeah.
Okay. All right. Now let's talk about some of the concepts. Premeditation. Did you understand the definition?
Yes.
The fact that the state doesn't have to prove a plan or a fixed time period, is that something that you can follow?
Yes.
Did you come into the courtroom with an idea of what you thought premeditation meant?
Yes.
Did it include a plan?
A plan?
Yeah, like that somebody, we heard from somebody else, like, I thought of it was like the person sitting in the garage, like making up all the plans and the diaries.
I thought it was just a thought.
Okay. Okay, so kind of in line with what definition.
Doing.
Okay. Do you think people can make big life-altering decisions quickly?
Yeah.
Okay. And what about the fact that the state doesn't have to prove motive?
Okay.
That's okay? You're not going to require us to prove something that the law doesn't require us to prove?
No.
Okay. Thank you very much, Juror 7. Let's go to Juror 10. Microphone's coming to you. Good afternoon.
Good afternoon.
Okay, so you raised your hand about law enforcement also. And
Yes.
the other way.
Yes. And the explanation on it was what I put down many, many, many years ago when I was younger. I had a fight, and a police officer accused me of hitting him, and I spent 2 days in jail.
Okay.
I got a witness that said I didn't do it, and I was let go.
Okay.
So I guess trust is still in the back of my head.
Okay, so you've had a negative experience.
Yes.
Is that negative experience with law enforcement going to cause you, back to our even playing field, to start law enforcement a little bit lower than other witnesses just because they're law enforcement?
I would say no.
Okay. Do you have a hesitation, or is it just that law enforcement officer that you dealt with?
Well, I won't say just him. I mean, it was like 40 years ago.
Okay.
I mean, I do trust police officers, and I
Okay.
have the utmost respect for them. So I don't think it would weigh on it.
Okay. All right. Your situation, I know you said that there was somebody who you had a experience with law enforcement in the court system, right?
Well, I never went to court.
You never went to court. Okay. Do you feel like I know you don't feel like you were treated fairly by that law enforcement officer, but all of your experiences through, like, kind of with the witness and just getting that process through, do you feel like you were treated fairly?
I would say yes.
Okay. So let's talk about some of these concepts. Premeditation. Did you come into the courtroom with an idea of what you thought that meant?
No.
Okay. Kind of a,
Never even thought about it coming into.
okay, all right. Well, we're going to think about it now.
I didn't know what I was going to get myself into. So.
Okay. Did you understand the definition?
Yes.
Can you follow it?
Yes.
Are you going to require us to prove things like a plan or a fixed time period?
No.
And do you think people can make big life-altering decisions quickly?
Yes.
What about how we know somebody's intent when they don't announce it to us?
I guess their actions.
Okay. And what about motive? The fact the state doesn't have to prove it. Is that okay with you?
Yes.
Okay, you can follow the law that if we prove A, B, and C, but you don't know why, that's okay with you?
Yes.
All right, thank you very much, Juror 10. Let's go to Juror 29. So you're going to pass the microphone back. Good afternoon.
Good afternoon.
Premeditation. Did you come into the courtroom with an idea of what you thought that meant?
I mean, I was the same with him. I didn't really know what I was going to
Okay,
get
you were
into.
you came in ready to
Yeah.
receive information,
Yeah.
right? Okay. Did you understand the definition?
Most definitely.
Okay, can you follow it?
Yes, ma'am.
Are you going to require the state to prove a plan or a fixed time period, even though the law doesn't require it?
No.
Okay. Do you think people can make big life-altering decisions quickly?
Oh, for sure.
Okay. How do you know what somebody's intent is if they don't announce it to you?
The same actions.
Okay.
Say,
Just
actions.
actions at the time, or what about actions before or after?
Just like before if anything happened, you can just kind of like tell. You kind of like see somebody's body language and how they move, and
Okay. And motive. If we prove A, B, and C, and obviously the judge will give you the law, right?
Yeah.
But if we prove beyond a reasonable doubt A, B, and C, but you don't know why, are you going to be able to find somebody guilty?
I mean, I'll be able to make a decision, but it just be sitting in the back of my mind.
Might not like it,
Yeah,
right?
Most definitely.
But even if you don't like it,
I'll
you
still
do
be
it.
able to make a decision.
Okay. And the question is, and are you going to hold it against the state if we don't prove a motive?
No,
It's
ma'am.
really what it comes down to because we don't have to.
Yeah, no, ma'am.
All right. Thank you very much, Juror 29. Let's go to Juror 27. Microphone's coming to you. Good afternoon.
Hi.
Law enforcement. You also raised your paddle about law enforcement. Did you hear my explanation about our even playing field?
Yes.
Okay. Is law enforcement getting that leg up from you because of your positive feelings about law enforcement?
I grew up in a family full of law enforcement, so it's kind of ingrained in me to kind of just believe them.
Just believe them? Would you agree with me that there are good police officers and bad police officers?
Yes.
Okay. So how will you know as a juror? And I'm not trying to change your answer. We're just talking it out. Okay. How do you know as a juror if a law enforcement officer comes in to testify if they're a good one or a bad one?
It's very tough.
Okay. Are they getting that kind of benefit of the doubt from you?
It's possible.
All right. Thank you very much, Juror 27. Let's go to Juror 21. Microphone's coming to you. I'm going to get somewhere where I can see you. Thank you all for assisting.
Good afternoon. Good afternoon.
So I saw on your questionnaire that you work with addiction and mental health clients.
Yes.
So what specifically do you do?
Specifically, I have my PhD and specializing in my thesis, and everything was done in chronic addiction, studying the mind, the brain, the actions, the habits, medication, etc.
Okay. Premeditation. Did you let's try that again. Did you come into the courtroom with an idea of what you thought that meant?
Of course.
Okay. How did it line up with what I read?
Like I think most of us said, that when we understand that it doesn't have to be a timeline, that it could be a minute, it could be a day, it could be a week.
Okay. And you can follow that?
Yes.
Do you think people can make big life-altering decisions quickly?
I think it's circumstantial.
Okay, what do you mean by that?
Meaning that if I'm giving something in my hand, tangible, say make a decision, I can make it. But if they gave me a question, I may have to take some time to think about it.
Okay. So kind of working through that. That's the way you would handle it,
Yes.
right? But would you agree that not everybody handles
Of course,
kind
everyone's
of big
different.
life-altering decisions?
Everyone's different
Okay. So maybe something you might think about for a long time, somebody might make a decision in 5
in a
seconds.
second. Absolutely.
Okay. How do we know somebody's intent if they don't announce it to us?
We always have to draw in the body signals, clues, actions, and facts. And we have to correlate those things to come up with a definite decision.
Okay. Motive. State doesn't have to prove it. We don't have to prove the why. We just have to prove that the crime, we have to prove what the judge tells you we have to prove, but that the crime was committed and that he's the one that committed the crime. Is that okay that you might have that unanswered question of why?
Of course, the law is the law.
Would you be able to find somebody guilty and not know why?
I follow the law.
Okay. All right. Thank you very much, Juror 21. Let's bring the microphone forward to Juror 2. Microphone's coming to you. Good afternoon.
Good afternoon.
Did you come into court with an idea of what you thought premeditation meant?
I guess I didn't think that it could have just been just a thought. Like I thought it had to be more
Like a plan?
like a plan.
Okay.
Not like a written out plan, but thought about it for a day longer. But yeah, I understand it could have been a
Okay.
thought.
Knowing that it doesn't require kind of what you came in thinking it required, a plan or day, can you follow it as I read it, if that's what the judge reads to you at the end of the case?
Yes.
Okay. Do you think people can make big life-altering decisions quickly?
Yes.
Okay. Even if it's a decision maybe you wouldn't make?
Yes.
Okay. What about the fact that the state doesn't have to prove motive?
I hadn't thought about it before, but yeah, I can separate it if A, B, C, like you said, evidence. Yeah.
Okay, so if A, B, and C don't include motive, if
I
we
under-
prove
yeah.
it, that could be enough for you?
Yeah.
Okay. All right. Thank you very much, juror number 2. All right, let's send the microphone back. Let's go to juror 32.
Hi.
Good afternoon. How are you?
Very good.
Did you come into court with an idea of what you thought premeditation meant?
I made some adjustments after you said the definition, but yes.
Okay, so you came in thinking one thing, but now that you've heard the definition, you've adjusted.
Yeah, there are a couple of things I never thought about. Like, for example, that you have to have, I mean, premeditation includes that you have to have a certain time to reflect on your idea. And I never thought about it. I mean, just never thought about it. But yeah, that includes it. So that's okay.
Okay. So do you think people can reflect and make a decision quickly?
People make decisions quickly.
Okay.
Some reflecting, some others don't, you know. But yeah, some people can reflect and have a decision. Yeah.
Okay. You're not going to require us to prove a plan or any of the things that you came in with thinking premeditation meant?
No, stick to the law. I think that's the most important thing.
Okay. How do you know somebody's intent if they don't announce it to you?
Yeah, I will probably repeat what everybody said. You know, you can see the actions, you can see the person, maybe comments, maybe I don't know, something that will tell me that patient. I'm sorry, but I work with patients, so yes. So the person was meaning to do something, or so not always is verbal.
Okay. And what about the fact that the state doesn't have to prove motive? Is that something you're going to require us to prove, even though the law says we don't have to?
As a human being, in my mind, I would love to understand, and always in my head, it'll always be the why. But you know, I'll follow the law. The law requires that you prove A, B, and C. I'll consider that as what is required from me, and I'll take a decision based on that.
Okay. All right. Thank you very much, juror 32. Let's go to juror 33. Good afternoon.
Hi.
Hi. Did you come into the courtroom with an idea of what you thought premeditation meant?
No.
Okay. So you're one of those open books ready to just receive information.
Yeah.
Okay. Did you understand it as I read it?
Yes.
Okay. Are you going to be able to follow it?
Yes.
Are you going to require the state to prove a plan, or that we prove that thought about it for a certain period of time?
No.
Okay. Do you think people can make big life-altering decisions quickly?
Yes.
Okay. Even if it's a decision maybe you wouldn't make?
Yes.
How do we know somebody's intent if they don't tell us?
By how they act.
Okay. And what about motive? The fact that the state doesn't have to prove why.
Yeah, I get that.
Okay. And I know you've listened to me ask these same questions to everybody, so
Go
you're
for
thinking,
it.
like, I'm ready to tee these up. But, you know, you heard from juror 32 right next to you, we're all human, right? And as a human being, you want to understand. But knowing that maybe you won't, maybe you will. We're not talking about the facts of the case. Are you okay following the instructions from the judge, A, B, and C? And if A, B, and C don't include the why, still finding him guilty?
Yes.
Okay. Thank you very much, juror 33. Let's go to juror 35. Good afternoon.
Hi, how you doing?
I'm doing well, thank you. How are you?
Great, thanks.
Did you come into court with an idea of what you thought premeditation meant?
I did.
Okay. Did that include a plan?
Yes.
Okay. So now that I read to you the definition, knowing that we don't have to prove a plan, can you follow the law?
Yes.
Are you going to require us to prove a plan?
No.
Okay. Are you going to require us to prove a fixed time period?
Can we hear that definition again one more time, please?
Sure. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt the existence of premeditation at the time of the killing. So, sure, there has to be a period of time, right? Because the law actually says that, but it says there's no fixed period. It has to be 10 seconds. It has to be 10 minutes. It has to be 10 days. It just is based on the evidence, right?
Right.
Okay, can you follow that?
Yes.
Do you think people can make big life-altering decisions quickly?
They do so all the time emotionally, yes.
Okay. Even if it's a decision maybe you wouldn't make?
100%.
Okay. And what about motive? The fact that the state doesn't have to prove motive?
It's not going to be a problem.
Not going to be a problem, even if, as a human being, you want to know why.
It's not going to be a problem.
Okay. All right. Thank you very much, Juror 35. Let's go to Juror 37. Good afternoon.
Good afternoon.
So you also raised your hand about law enforcement, kind of hearing the explanation about kind of our even playing field. Do you feel like because of your positive feelings about law enforcement that you will be giving them that extra leg up before they start testifying?
I would try not to give them a leg up, but I'm
Okay.
for law enforcement.
Would you please repeat and
I would
speak up?
try. I would try not to give them a leg up, but I am for law enforcement, if that makes sense. I
Okay.
would try.
Okay. And I want to make sure I understand because sometimes people use the word try because they're unsure they can. And sometimes people say, I'll try because they've never been in this situation before. And we're asking them to tell us what they'll do in a situation they've never been in. Or it's something else. So where do you kind of fall?
I think I would have to listen carefully to the law enforcers, them speak, and then try to get a balanced opinion or thoughts on
Okay.
it first.
And that's what we're asking you to do, right? Is to listen before you make a decision. What we can't have you do is make a decision when a law enforcement comes and sits on the witness stand. Immediately, I'm going to believe that person because they're law enforcement when they haven't said anything. That's really what we're trying to make sure. So can you do that? Listen to the evidence before you decide if it's credible.
Yes, I can listen to the evidence first.
Okay. And I want to talk to you about premeditation. I'm sure you could have seen that coming. Did you come into the courtroom with an idea of what you thought that meant?
I did not.
Okay, so you're one of those open books.
Open book.
Can you follow the law as it was read to you?
Yes.
Okay. Are you going to require the state to prove those kind of that extra part, a plan or a fixed time period?
No.
Do you think people can make big life-altering decisions quickly?
All the time.
Okay, even if it's not one maybe you would make?
That's true.
Okay. And what about motive? The fact that the state doesn't have to prove why?
I think I would, in my mind, I would be wondering why, but I understand that they don't have to.
Okay.
Yep.
If you're left, you're allowed to wonder, right? You're allowed that we're all human beings. We can't ask you to not wonder. What we can't have you do is kind of add that as one of those, basically instead of A, B, and C, adding D because you are wondering. Do you see what I mean?
I do.
Okay, so are you able to kind of wonder but not let it affect your verdict?
Yes.
Okay, thank you very much, Juror 37. Let's go to Juror 50. Microphone should be coming to you. Good afternoon.
Good afternoon.
So you're very soft-spoken, but I saw in your questionnaire that you worked for the New York City Police Department. Did I get that right?
Correct.
What did you do for the
Can I ask you to speak up a little bit, please, for me?
That's correct. I used to work for the school safety.
Okay.
We're underneath the police department.
Okay. How long did you do that?
21 years.
Okay. My same question for you about law enforcement. I know I don't think you did raise your paddle, but I'm still going to ask you you start all law enforcement officers on that same even playing field before they start talking?
Correct.
Okay.
She said correct.
Correct.
Did you come into court with an idea of what you thought premeditation meant?
I was just open. I just came. I didn't know what I was coming for.
Okay. Can you follow the law as it was read to you?
Yes.
Okay. Are you going to require the state to prove a plan or a fixed time period?
Yes.
You are going to require that? Even though it's not included in the definition?
No.
Okay. So the definition says there's no fixed time period. It just depends on the evidence. Can you follow that?
Yes.
Okay. And do you think people can make big life-altering decisions quickly?
Yes.
And what about motive? The fact that we don't have to prove a motive. Can you follow that?
Yes.
Okay. Thank you very much, Juror 50. Let's go to Juror 49, right next to you. Good afternoon.
Good afternoon.
I bet you can tell me the questions at this point, probably. That's what happens when we get back there. So I apologize for that, but I'm going to try to be as quick as possible. Did you come into court with an idea of what you thought premeditation meant?
I did.
Okay. How did it line up with what I
You
read?
changed that opinion.
I changed that opinion. Okay. And again, the law comes from the judge, but as I read it, that's obviously what comes from the judge at the end of the case. Can you follow it, even though you maybe came in with a different opinion?
Yes.
Okay. Did your opinion include a plan?
What do you mean?
Like when you came in, when you came in with your idea of what premeditation meant, did that include a plan?
It did.
Okay. Are you going to require that from us?
No.
Okay. Do you think people can make big, life-altering decisions quickly?
Yes.
And what about motive? The fact that we don't have to prove motive. Can you follow that?
I can.
Okay. Even if you as a person, let me see if I can get to where I can see you. As a person, may want to know why. Are you okay with the idea that maybe you may not and still have enough to find somebody guilty?
Well, maybe not okay, but if you tell me that's what I have to do.
Okay. So that's a fair assessment, right? You might not like it, but you can do it?
Yes.
Okay. All right. Thank you very much. Let's go next to you to Juror 48. Good afternoon.
Hello.
All right. Let's talk about premeditation.
Counsel, can you approach, please?
Juror 48, are you still with me?
Still here.
All right. Premeditation. Did you come in with an idea of what you thought that meant?
Yeah, it was very similar to what you said, as long as it's something before. You intended to do it before.
Okay. Can you follow that?
Yes.
How do you know what somebody's intent is if they don't announce it to you?
I'd say their actions before the event occurred.
Okay. Like what? I know I caught you off guard because that was a different question than I asked anybody else. I didn't mean to do that to you.
If they brought a weapon, or if they did have a plan, if they made movements and actions towards the person being killed beforehand that indicated they wanted to kill them.
Okay. Do you think people can make big life-altering decisions quickly?
Yes.
Even if it's not a decision you would make?
Yes.
All right. And what about motive? The fact that the state doesn't have to prove it?
If the court says it's not required to prove it, then I follow the court.
Okay. All right. Thank you very much, Juror 48. Let's go to Juror 45. Good afternoon.
Good afternoon. How you doing?
Your paddle went up, and as soon as I said your number, I said he wanted to talk to us. So
Yes,
before I talk to you, you talk to us.
Yes, does it premeditated means you have to think before you do something?
Well, premeditated, the court's going to instruct you on what premeditated means.
Okay.
Okay, did you hear what I read?
Yes.
Okay, did you understand it?
Yes.
Can you follow, if that's what the court reads at the end of the case?
Yes.
Can you follow it?
Yes, ma'am.
Okay. Did you come in with an idea of what you thought it meant?
Well, it's kind of sort of.
Okay. Did you think that it meant that we had to prove a plan?
Not really.
Okay. What did you think it meant?
I just think you have to think about your actions before you do something.
Okay. All right. Do you think people can make big life-altering decisions quickly?
Yes.
Okay. Sensed a little hesitation.
Yes.
Okay. Would you make big life-altering decisions?
Oh no, I have to think about what I do.
Okay. Do you accept the fact that just because you wouldn't make a big life-altering decision quickly, that maybe somebody else might?
Right. True.
Okay. What about motive? The fact that the state doesn't have to prove motive.
They really don't.
Okay. So you accept that, and if we prove what we have to prove,
Yes.
you could find somebody guilty even if you don't know why.
Yes.
Okay. All right. Thank you very much, Juror 45. Let's go to Juror 41. Microphone's coming to you.
Hello?
Good afternoon. Am I seeing it right that you're an attorney?
Correct.
What kind of law do you practice?
Private wealth and M&A, anything that relates to tax.
Okay. Have you practiced any other kind of law?
No.
Okay. And I also saw that you have a significant other that is also an attorney.
Correct.
What kind of law?
Employment litigation.
Okay. Ever any criminal law?
No, she interned with the Middle District
Okay.
for a little bit. I don't know if it was with the criminal division or
Okay. How long ago would you say that was?
I would have been 2022.
Okay. Anything about that that you think would affect your ability to listen to, the law coming from the court and, follow the laws here in court?
I don't think so.
Okay. And I also saw that you are acquaintances. I think you wrote acquaintances
Mhm.
with attorneys that do work in criminal law.
Correct.
Anything about those relationships that would affect your ability to be fair to both the state and the defense?
No.
Okay. So let's talk about the concepts. Did you come in with an idea of what you thought premeditation meant?
Yes.
Okay. How did it line up with what was read here in court?
Pretty spot on.
Okay. Can you follow it?
Yes.
Do you think people can make big life-altering decisions quickly?
Absolutely.
Okay, even if they're maybe not decisions you would make?
Yes.
Okay. What about motive? The fact that the state doesn't have to prove motive. Can you follow that?
Mm-hmm.
Is that yes?
Yes.
Okay.
Yes.
Do you have any hesitation about potentially, if we prove it, finding somebody guilty if you don't know why?
No.
Okay. Thank you very much, Juror 41. Let's go to Juror 52 behind you. Good afternoon.
No.
Saw in your questionnaire that you had some family members who had been through, a family member maybe, that had been through the criminal justice system.
Yes.
Did I get that right?
Yes.
Do you feel like your family member was treated fairly
Yes.
by the state? Was it here in Palm Beach County?
No. In other states.
Another state.
Mhm.
Okay. Did you feel like your family member was treated fairly?
Yes.
Okay. Any issues with the court system or law enforcement because of those experiences?
No.
Okay. So let's talk about premeditation. Did you come in with an idea of what you thought that meant?
I assumed decision and a plan of some sort, even if it was a short plan, but I understand from the definition that planning is not necessarily part of it, but the decision part is.
Okay. And you can follow that?
Yes.
Okay. Do you think people can make big life-altering decisions quickly?
Assuming they are of sound mind,
Okay.
yes.
What do you mean by that?
Just assuming that someone is mentally capable. If someone has mental deficiencies that don't allow them to make reflexive decisions, then no, obviously.
Okay.
But generally speaking, I think most people are, yes, capable.
Okay. I understand what you're saying now.
Yeah.
How do you know somebody's intent if they don't tell it to you?
I suppose that's difficult to actually know, but I think you just have to go by context clues, like, behaviors and that sort of thing to make a determination.
Okay. And the fact that the state doesn't have to prove motive. How do you feel about that?
I like a whole picture, just, that's the way my brain works, but I do understand the limitations of the requirements, and what's required is required, and you don't have to prove anything beyond that.
Okay, so if the court tells you it's A, B, and C, and we prove
Correct.
A, B, and C, that's enough?
Yes.
Okay. Thank you very much, Juror 52. Judge, can I just have a moment?
You can.
Thank you. Okay, so I have a couple of questions that are kind of big picture questions to the whole group. All I need you to do is if this applies to you, just raise your paddle, we'll mark it down, and then maybe follow up depending on the question. Okay, so the first question, everyone got your paddles ready? All right. The first question I have for you is there anybody that for a religious belief feels that they cannot sit in judgment of another person?
I'm going to interject. Here, you're not judging people, you're judging the facts and whether or not the state has met each and every element of the charge. So I just want to modify that. With that, you can proceed.
Anybody else? I'm not seeing any hands. Okay, the other question is kind of like a big umbrella question. It's to the whole group. I know there are I spoke to some of you. I did not speak to all of you. Just by a show of paddles, is there anybody that thinks that, I have something that you didn't ask me about that if I were you, I'd want to know before I picked this jury? Just by a show of the paddles. Okay, just hold them up. I'm going to say, okay, we've got 31, 6, 38, 46. Anybody else? 10, 40. Okay. Anybody else? 31, I'm sorry. I got you. Okay, if we could get a microphone to juror 10. I don't mean to pick on you. All right, let's have a role reversal. What do you think I need to know?
I don't think I would feel comfortable listening to the testimony about the death of a child.
Okay. Now, and that's fair. Let's talk about that, though. Let's unpack it, because fact of the matter is probably nobody in here wants to do that. I would imagine. So the question is not, are you comfortable? Because I'm not going to sugarcoat it. It's not being a juror is hard. It is. And a case like this, you've heard it's heavy. Can you? And I ask you that, and that's kind of a broad question. But I mean, we can't have jurors that are going to sit and close their ears and close their eyes and not pay attention because they physically cannot receive the information. But if it's going to be hard, while we very much respect that and we understand those limitations, and I'm glad you told us because we do want to know if that's going to be that way for you. Those are two different things. So do you fall in the I'm shutting down and I'm not listening? Or do you fall in the please don't make me do this, I really don't want to?
Probably the latter.
Okay.
But could I do it?
Appreciate your honesty on that.
Could I do it? I believe I could.
Okay, but you don't want to. And that's fair. Did I get that right?
Well, when you say don't want to, I
mean
do want to, but just knowing what type of case it is, I just feel a little uncomfortable.
Understood. And that was my poor choice of words. I didn't mean that you don't want to do your civic duty and serve. I meant that you are concerned about kind of the content. Would that be fair?
That's fair.
Okay. All right. Ladies and gentlemen, thank you so much for your time and attention. I'm going to turn it over to the defense.
Well, you're going to turn it over to the court. Maybe the court will turn it over to the defense. Approach, counsel, please. Ladies and gentlemen, we're going to take a break. It's been a little bit more than an hour since you've been sitting there. I think probably some need to take a stretch break. It'll be a short break. Is 10 minutes sufficient for all of you? Anyone want more than 10 minutes? Raise your paddle. You want more than 10 minutes, 7? You want more than 10 minutes? You want 15? All right. 15 minutes. We'll come up. Please be back here by 3:15, 3:17. Enjoy your break. No texting, tweeting, blogging, emailing, sending or accepting messages, communications of any kind about this case or your jury service. We cannot start if anyone is not here. So please, everyone, be back on time. Thanks. Yes. could you take the break and then we'll just make sure you tell deputy that you want to come back and. Well, let's wait. Just come back. Just come back. Thank you. It's okay. Please come back. Thanks. Thank you. Are they gone? So, Mr. Williams, your attorneys asked to come to the bench to ask me to explain to you why there are still jurors here, even though we all agreed that they should be excused.
Yeah, that's kind of confusing.
All right, I'm going to explain that to you, okay? So, I don't want anybody to get any ideas about how to get out of being on the jury. So, I'm keeping everybody here so that the rest of the jurors don't know who all is leaving. But I've instructed the attorneys not to ask any questions of those individuals so we don't call what's called poison the panel. Is that okay?
Okay, it was just confusing. I didn't know what was going on.
All right. Did I straighten that out?
Yeah.
Are you still satisfied with your attorneys?
Yeah, I mean, they been having the history of lying to me, but I still work with them because I just want to. Sometimes they do a pretty good job. Sometimes though.
Well, I want to make sure that as we sit here now, they've done everything you've wanted them to do. So far during this trial, is everything okay?
It's pretty good. I have a question.
Yes, sir.
I'm talking to you right now. I'm having a conversation. So, I just wanted to. I'm thinking it was okay to just. Could I bring my police report so I can just remember things about my case and review it while I'm here?
We'll talk. Let's talk about that. Let's take a break, and then let's talk about it when we come back. Can you remind me when you come back about that? You can have materials here at the desk, so that's not a problem.
Yeah. Actually, I have my police report, and I'm good. She can hear me.
Well, we want to make sure that the court recording is taking.
Okay. Well, I have my police report at jail, and they told me that I could take legal papers, and I just want to have my police report so I can just remember things about my case and things like that. Okay. Is it okay if I bring it?
Well, I have to get some more information. So you're asking me to give you an answer right now, and I just need a minute just to make sure that that's okay. Is that okay with you?
Okay.
All right. Thank you, sir.
Okay.
Other than that, are you still satisfied with your attorneys?
We just as long as I can present my case the way I want, then I'm okay.
Well, we haven't even gotten to the presentation yet. I'm just talking about where we are right now.
So far it's going okay.
So everything is going good so far?
Yeah, everything's going okay so far.
Is there anything you wanted them to do so far that they haven't done?
Not right now.
All righty, sir.
Thank you.
If it's okay with you, we're all going to take a short break and come back, and then I'll try to get an answer to that question, okay?
Okay, I appreciate it.
Thank you, sir. Okay. Can someone from corrections meet me, please? Thanks. So, Mr. Williams, before we took that break, you asked me about being able to take your papers. And I've spoken to the sheriff's department. And other than anything that's causing security issues, they'll let you bring any papers, any legal papers to court, okay?
Okay.
So if it's a security problem, you can't bring that to court, okay?
Okay. Oh, so police report will fall under legal?
Yeah, it's papers. So they'll allow you to bring those papers. But if there's anything that's going to be like a security risk, they can't let you have that. You know what I'm saying?
Okay. Thank you. Appreciate you.
Are you ready for us to bring in the jury? Mr. Williams? Yes. State, are we ready? Yes. Thank you. Let's bring in the jury. How much time do you all think you'll need for the conference? Because based on the timing now, I just want to know if they're going to stay past 5.
I don't think we would need to stay past 5 unless
We're good?
changes or something. But yeah.
I know it's all
Right,
it's all fluid, but as we stand right now,
no, I think we shouldn't be past 5.
oh, counsel also, if you don't mind approaching. Please be seated. I hope you enjoyed your break. Just to kind of give you a sense of how the day is going to hopefully run, the defense is going to ask their questions of you. Then we're going to have that conference I spoke to you about this morning. You cannot be present for that conference where the jury is actually selected. It's conferences between the attorneys, Mr. Williams and myself. We hope all of that, and then when you'll come back in and then we'll announce who the jurors are. We anticipate all of that will be done by 5. It may be 5:30 if something squirrely happens. So I just want to give you all a sense of timing for that. But today you will know who is going to remain for the trial and who is going to be excused. With that, Ms. Wilson, you may proceed.
Good afternoon, everyone. I know it's been a long day. I have to speak to you last after you've been sitting in those uncomfortable chairs all day. So I appreciate your patience and attention with me as it's really been repeated to you throughout the day today. This is a very, very important, perhaps the most important part of a trial, because those of you who are selected for this jury are going to be tasked with making a very important decision. And we just want to make sure that Mr. Williams, the jurors that end up seated in his jury are truly fair and impartial, and that he will have that fair trial. So I want to kind of start off where we ended with what Juror 10 was talking about the nature of this case. I think most of us, or all of us, I hope, would agree that cases involving harm to a child, and especially the death of a child, affect people very deeply. It's upsetting, it's a tragedy, and I think most people are emotionally affected when they hear about something like that. But some people are able to put those emotions aside and kind of would be able to focus strictly on the evidence and take those emotions out of their deliberations. But some people just truly are not able to do that given the nature of this case. And neither is right or wrong, but only you all truly know where you fall and your ability to do that. And kind of along with that, you know, we've talked, or the judge has talked to you about the presumption of innocence and how important it is in a criminal case. But I think sort of talking about the presumption of innocence in theory can be easy to agree with, but actually applying it sometimes is more difficult. And for some people, truly applying the presumption of innocence in a case that involves the death of a child is difficult or impossible for them. And so I want to talk to you all about your feelings about your ability to truly be fair if you were picked as a juror in this case, given that a child has died, and your ability to truly presume Mr. Williams innocent, given the nature of this case as well. And so, Juror 10, I'll just start with you because we ended with you. I know you already talked a little bit about this, but do you believe that you could be a truly fair and impartial juror on this case, given the nature of what it involves?
Yes.
Okay. If for any jurors that are selected, you would likely have to be viewing evidence of graphic photographs, autopsy photographs of a child, crime scene photographs involving a child. Would you be able to do that?
That would be the tough part, but I believe I could.
Okay. Do you have a concern that you might not be able to?
No.
And as we sit here right now, are you able to look at Mr. Williams and see him as innocent?
Yes.
Do you think that in a case like this, presuming innocence of Mr. Williams is in some way disrespectful to the Rogers family, the family of the boy?
Not if the evidence proves it that way.
Okay.
He's innocent or guilty. We're going to take the information and make a determination from it.
Since you have the microphone, I just want to ask you about another topic that was mentioned in the blurb that this judge read to you this morning about the case, and that involves homelessness. I was wondering if you had any experiences or personal experiences or interactions with individuals who experience homelessness.
No.
Do you think that people who are homeless are more likely to commit crimes than those who are not?
I don't think so.
Thank you. If you can pass the mic to Juror 7. Good afternoon.
Good afternoon.
You had mentioned, well, let me ask you this. What do you think about being a juror on this type of case?
I don't know.
You say, I don't know?
Yeah, I don't know.
Okay. What do you mean about that? Like by that?
I don't know any of the facts or anything other than what's been said so far. So,
Does the fact that it involves the death of a child concern you about your ability to be fair?
it's disturbing.
Does it concern you about your ability to be fair?
A little bit, yeah.
Okay. Can you just explain that to me?
It's the death of a child. It's not easy. Not sure if I'd want to see those pictures or hear the description of how it happened.
Mm-hmm.
So I guess it might impact, yes.
Okay. So do you have a doubt that you would be able to truly be fair and impartial given the nature of this case?
I don't know.
Thank you. You can pass it down to juror 2. Hi, good afternoon.
Hi, good afternoon.
Sort of the same question about the nature of this case. And again, I think it's difficult for most people or just about everyone. So what we're concerned is that, or curious about, and concerned that a juror might just, the emotional nature of this case would overwhelm their ability or affect their ability to impartially evaluate the evidence and be a fair juror.
I would like to say no, but I do have concern, like a child. I don't have children, but I have children in my family. Like, I don't know. Like, I do have concern whether that, like, seeing those things, if I would be like, obviously you have to, like, evidence, but I don't know. Like he said.
I appreciate you being candid with us. If you could pass it back to juror 11. Good afternoon.
Hi.
What are your thoughts about this topic?
I think I could be impartial and go by what the evidence proves or not proves.
And as it relates to individuals who experience homelessness, do you have any personal, experiences or interactions?
No.
Do you think that individuals who are homeless are more likely to commit crimes?
I don't know, honestly.
Thank you.
Okay.
You can go to juror 14.
Hello.
Hi. How do you feel about if you were a juror and your ability to be a fair juror in a case of this nature?
I definitely think it'll be very hard to see. But I have split sides of me, and being a mom, I want nothing but justice for that family. And then being a citizen, I want nothing but that person be proven guilty as opposed to just assuming guilt. So I have two sides to me that feel pretty passionate on both sides of that argument.
Let me ask you this. Hypothetically, if you were a juror and you felt at the end of the case that the state had not proven every element beyond a reasonable doubt,
Mm-hmm.
do you feel that a verdict of not guilty, would you still be able to render a verdict of not guilty?
Yeah, I think it would be more disjustice. So that's such a word, disjustice, to ruin two lives. So it has to be proven with beyond a doubt. I wasn't there, so I don't know until it makes me feel like I was there.
And as it relates to homelessness, do you have any experiences or personal experiences with individuals?
No personal experiences.
Okay. Do you think that individuals who are homeless are more likely to commit crimes?
I don't think so.
How come?
What? Say again?
How come?
I guess I just have a lot of empathy for homeless people that I can't imagine a person choosing to do that, to be homeless. I feel very privileged myself, so I have empathy for homeless people. So I don't generalize, try not to generalize anybody.
Thank you. If you can pass it to juror 17. Hi.
Afternoon.
Afternoon. Do you have any experiences, personal or otherwise, with individuals who experience homelessness?
I mean, I've known people that were homeless in my neighborhood.
I didn't hear the last part.
I said I've known people that have been homeless in my neighborhood, yes.
Okay. And do you think that just because somebody is homeless, they're more likely to commit a crime?
it all depends on what the person is homeless for.
Okay.
So there's several different reasons why people are homeless.
Mhm.
So it all depends. Some have drug addictions and things that put them in that position, right?
Mhm.
So, and then there are some that just like hard times.
Mhm.
So there's a difference.
And in terms of how that relates to sort of maybe they're more likely to commit crimes, it sounds like, how does that, where does, if it's just hard times?
I don't think so. It's my question, no, I don't think so.
Okay.
My answer, sorry.
Repeat what you just said.
My answer is no. I don't think so.
And in terms of what we're talking about with the nature of this case and the fact that it involves the death of a child, do you feel like that you could still be a fair juror given that?
I mean, I'll be fair, you know. So I have kids, so I understand, you know, that burden. So it's I'll be fair.
Do you know, if you had to view evidence of autopsy photos or crime scene photos involving a child, would you be able to do that?
It'd be tough, but if I have to do it.
And as you know, relates to what I was asking juror 14 about, you know, if the state hasn't proven every element beyond a reasonable doubt, would you still be able to render a verdict of not guilty?
Yes.
Okay, thank you. If you could pass it next to juror 18. How do you feel about what I've been talking to your fellow jurors in regards to the nature of this case and that it involves the death of a child?
Oh, I can't imagine anybody not being concerned with the circumstances surrounding the case. However, you also have to look at the fact that there's another human life that is in the judgment of the balance as well, too. So,
as we sit here today, knowing the nature of the charge, are you able to truly presume Mr. Williams as innocent?
absolutely.
And if you're picked as a juror and you were to see testimony from a family member of the child, you know, which will be probably emotional testimony, do you feel like any sympathy or empathy you might feel towards that family member could influence your verdict or how you look at the other evidence?
I mean, I can't imagine it not affecting me, but would it be biased in my judgment? I don't believe so, no.
And as it relates to individuals who are homeless, do you think that because somebody is homeless, it makes them more likely to commit a crime?
Definitely not. I have quite a bit of experience working with a lot of different homeless groups throughout the country, so got some insight to that.
If you could pass the mic back to juror 29. How do you feel about the fact that this case involves the death of a child and your ability to be a juror on this case?
I mean, I'm the same as everybody else as far as with kids. You know, I do have 2 kids, so as far as a parent, you know, I feel strong and passionate about like the death of a child. But I still think I can be fair. I could try to be fair. It'll be kind of hard for me, you know, especially like seeing photos and everything of a dead child. I don't know if I'll be able to do something like that. And as far as hearing a testimony from the parents, you know, I don't know if that will affect my decision at the end.
And we've heard sort of from some jurors to say that they can kind of put their emotions aside, and other jurors candidly saying that they don't think they can.
Yeah.
And so it sounds like, but I don't want to put words in your mouth, that you're saying that you're not sure if you'd be able to be a fair juror given the nature of the evidence and the nature of that case.
Yes, ma'am.
Yes,
ma'am.
Thank you. If you could pass it back to juror 37. Hi.
Hi.
What do you know, same questions to you about the nature of this case. and your ability to be a fair juror?
Well, I have children and I have 2 grandchildren.
Can you just speak
I
up
have
a little bit?
I have children. I have 2 grandchildren.
Okay.
So I think I would think about it. It would be on my mind.
Okay. Do you think that you could be a truly fair and impartial juror for Mr. Williams in this case?
I would try. It's a tough one. Yeah.
And when you say, that you could try, that gives us attorneys a little pause sometimes.
Yes.
And so, do you have a doubt that you would be able to do so?
Again, I'll use my answers. I would try. So that's the best one I got for you.
Thank you. If you could pass it to juror 35, please. Hi, good afternoon.
Good afternoon.
How do you feel about your ability to be fair?
I can be fair.
Okay. And
Is this juror 29?
This is 35.
Thank you.
And do you have any, given the fact that a child has died, can you look at Mr. Williams right now and truly presume him innocent?
Yes.
Okay. And in terms of looking at potentially graphic evidence,
I've seen a lot. So this one's a little different. It's a 14-year-old boy, but I've seen a lot.
okay. And in your questionnaire, you had mentioned maybe some personal experience, having witnessed a crime and someone close to you, a victim of a crime.
Yeah.
Okay. Are you all right talking about that in front of the group? Or?
Not the victimizing part, but the witness, yes.
Okay, was it the same crime or was it 2 different things?
2 different crimes.
Okay, what type of crime did you witness?
Carjacking. My
Okay.
wife and son, my infant son, were attempted carjacking.
Anything about, was that recent or?
No, it was quite a few years ago.
Okay, anything about that experience of you witnessing that crime that would, you think, come into play, affect your ability?
No, not at all.
And as it relates to your wife being a victim, is that something, obviously we know the nature of this charge that we're here today for. Do you have any concerns that would come in to play and be on your mind, given the nature of this case?
No, not at all.
And how long ago was that?
2003, 2004.
And then in terms of individuals who experience homelessness, do you have personal experience working?
A lot, actually. Yeah. I've worked with homeless since I was in high school, through my ministry and everything else. Yeah, of course.
Okay. So do you think that just because somebody's homeless, it makes them more likely to commit a crime?
No. I mean, doesn't matter.
If you could pass it down to juror 33. Good afternoon.
Hi.
Do you think that you could, given the nature of this case and that it involves the death of a child, do you believe that you could be a fair?
Yes.
Okay. How come?
Because no one's guilty yet.
Do you think that if you were a juror and were to see testimony, emotional testimony from a family member, that would influence how you viewed the evidence in this case?
No.
And in terms of individuals that are homeless, do you have any experience with that?
No.
Do you think that because somebody is homeless, they're more likely to commit a crime?
No.
How come?
Because they're still humans and they still know right from wrong.
Thank you. You can pass the microphone next to you to juror 32. Good afternoon. Do you have any experience with individuals that experience homelessness?
Yes, I'm a nephrology nurse. So I've had some patients that they need dialysis and they happen to be homeless. Yes.
And do you think that because somebody is homeless, it makes them more likely to commit a crime?
I don't know any statistics about that. I can tell you about illnesses, but crimes, I don't know.
I'm just asking if you have any thoughts about it, if you think,
No, I don't. I try not to judge based on social economical status. That's, everybody's, I have seen people from way different socioeconomical status committing crimes. So I don't know.
How about sort of the nature of this case, that it involves the death of a child? How do you feel like you could still truly be fair in this case?
I'm a father of two beautiful girls, but I think I can be fair. Mr. Williams deserves justice. That's what I think. He deserves a fair trial. So I think I can be part of that.
If you could go behind you to juror 41, please. Good afternoon.
Good afternoon.
So how do you feel about the fact that this involves the death of a child and your ability to be a fair juror in this case?
I mean, obviously it's tragic, but I think I can put that aside.
In terms of viewing graphic evidence and photographs, is that something that you think you'd be able to do in a unbiased, impartial way?
I believe so.
Okay. Do you think that if the state had not, say hypothetically, you're a juror on this case and the state, to you, has not proved every element beyond a reasonable doubt, do you think that returning a verdict of not guilty would be disrespectful to the Rogers family?
No.
Okay, and how come?
It's more about his innocence rather than, obviously it's tragic what happened, but what's being asked here is whether he's innocent or guilty.
Thank you. And do you have any experience with individuals who are homeless?
No.
Okay. Do you think that just because somebody's homeless, it makes them more likely to commit a crime?
No, I don't think so.
If you could pass the mic to juror 45. I can't see because
morning.
juror 35, but that's my fault for being
Good
short,
evening.
not his. You don't have to duck down, juror. Good afternoon. How do you feel about the nature of the case, sort of the same questions I've been asking your fellow jurors, and your ability to be fair?
Yes, I believe I can be fair about it.
Okay. Do you think that, if you heard testimony from emotional testimony from a family member, that your emotions about that might factor into your view of the other evidence?
No, I just got to hear about the case before I can decide anything,
And do you think that people that are homeless are more likely to commit crimes?
Oh, sure they are. I have a friend of mine. He was on drugs real bad and enemy necessary. He did whatever to survive, and I try to help. And that like to say they are more vulnerable to commit crimes.
Okay, so let me ask you this hypothetically. Let's say I'm not talking about this case, but I'm just talking about a hypothetical case.
Yes, ma'am.
And the state, presents its evidence of the case, and in one scenario, the defendant, the accused,
Yes.
is homeless. In one scenario, they're not homeless.
Yes.
Okay, everything else is the same, right?
Yes.
Do you think that in those two scenarios, you're more likely to find the person guilty, the homeless person guilty, versus the unhomeless person?
Oh, like I said, I had to hear the evidence first before I
Okay.
decide anything. I just can't just up and decide. Up and say anything I don't know nothing about.
Sure, and I guess I'm just wondering because I've heard some people say that, well, I'm not sure if this, maybe the state didn't prove it totally, or I'm not sure. I'm kind of on the fence, but the person was homeless, so they probably did it because
Yes.
of their
Yes.
situation, right?
Yes.
Do you fall into that camp? That's just what I'm kind of wondering.
No, I guess I still got to hear about the evidence. I got to
Okay.
hear, whatever the crime that they did, whatever.
And I think I saw.
pleasantry, but
Sure. I don't think it's pleasant for anyone per se, but do you think that, that given the emotional nature of this case, that you would be able to set aside any emotions you might be feeling as a juror?
I'm sure I could. It wouldn't be easy to see pictures that you might close your eyes and still see them in your mind after you close your eyes.
Do you think that, given the nature of this case, that a child has died, that someone just has to be held responsible?
I'm not sure what you're asking me.
Do you think that if you were a juror on this case and the state had not, to you, proven every element beyond a reasonable doubt, but you heard testimony from a grieving family member, you know that a child has died, do you think that even if the state hadn't proven the case beyond every reasonable doubt to you, that you would still maybe say, well, a 14-year-old was killed, Mr. Williams, someone has to be held responsible. Mr. Williams is sitting here, so I'm going to find him guilty.
No.
Do you think a not guilty verdict in this case would be disrespectful to the Rogers family?
No, because we're not saying that he's guilty, so Mr. Williams might not be guilty of what he's being charged of.
If you could pass the mic next to you to juror 50. Good afternoon, ma'am.
Good afternoon.
So, you say 21 years with the NYPD?
Yes, ma'am.
Okay. And so, you indicated that you would not give police officers sort of a leg up in credibility just because they're police officers. Is that fair to say?
Repeat that.
Ask it a different way. So if you were to hear testimony from a witness, a police officer, a witness in law enforcement, would you be giving that witness more credibility solely because they are a police officer?
I don't trust police officers.
Yeah, can you speak up, please?
I don't trust police officers.
Okay. And would you be able to evaluate a witness, a police officer witness's testimony, just like any other witness that you hear from?
Yes.
How do you feel about what I've been talking to your fellow jurors about regarding the nature of this case and your ability to truly be a fair and impartial juror, given the nature of it?
Well, I believe innocent till proven guilty, but
you're going to have to speak
I
up, sorry.
I believe innocent till proven guilty, but I work with them, in New York, and I know certain things they do,
Police officers?
Yes, ma'am.
Okay. All right. And so in terms of the fact of this case involving the death of a child, okay, do you feel like you could be a fair juror given the nature of this case?
Yes.
And in terms of individuals who are homeless or experiencing homelessness, do you have any experience with that?
Working in the school, I have homeless kids and stuff like that. Yes.
Okay. Do you think that homeless individuals are more likely to commit crimes than those
No,
who
I
are
don't
housed?
No, I don't believe that.
And how come?
Everybody's different,
Thank you. If we could go back to juror 58. Good afternoon.
Good afternoon.
How do you feel about being a juror on this type of case? in terms of your ability to be fair and impartial?
Yeah, I think I could be fair.
Okay. Do you think that the emotional nature of maybe some testimony or photographs that you might see would sort of cloud or influence your ability to look at all the evidence?
No.
And as it relates to homeless individuals, do you think that people that are homeless are more likely to commit crimes?
No.
And why not?
I don't think that that's a precursor probably for committing crimes.
And I think you said that you have a cousin that works for the sheriff's office.
Correct.
And I think there might be one or two, a couple of witnesses from the sheriff's office in this case that the state read out. Do you think that the fact that you have a family member that works for that organization would view how you affect the credibility of the law enforcement witnesses in this case?
No.
Thank you. If you can pass it to juror 55.
Hello.
Hi. How do you feel about your ability to be a fair juror given the nature of this case?
I think it's a very sad case on both parts, but I think that after hearing the facts, I'd be able to make a decision according to the law.
And as it relates to individuals who are homeless, do you have any experience with
I've
that
had
as-
experience with the homeless. I'm actually a nurse, and I've had a personal experience with them. I've helped homeless people, but like most people have said, it depends on that person. Everybody is different. There's some people that don't choose to be like that. There's people that have served in this country that are like that. So I have no opinion.
And if you could pass it next to you to juror 54. Good afternoon, sir.
Good afternoon.
How do you feel about your ability to be a juror on this case, given the nature of the charge?
I mean, obviously, as we stated before, it's quite a heavy case, to deal with. Really, although considering that, of course, you have to really look at the evidence presented and nothing really more than that, and go from there, and use what's presented to you to be able to make that judgment. Really.
Do you feel like you could set aside any sort of emotional reaction to some of the evidence and we'll just set aside any emotional reaction to the evidence?
I would say it would be tough, but that's what's needed, so I would say yes.
And you think you'd be able to do that?
Yes.
I didn't hear the response.
Yes. I would.
Thank you.
And if you could pass it next to, or not next to, juror 52, two down.
Hello.
Hi. How do you feel about your ability to be a juror on this case, given the nature of the charge?
I think, as everybody else has said, it is a very distressing context, right? And I will preemptively, because of the other questions you've been asking, say that I have empathy all the way around. And I have no doubt that I'll have emotional reactions to things. However, that said, I also know that our job is to deal with facts and facts only. And so it's just what you have to do.
And in terms of individuals who are homeless, do you think that makes them more likely to commit crimes?
No, I was a school. I worked for the school district for 35 years, and I had plenty of homeless students. So I don't think it's necessarily a question of that at all.
Okay. And it sounded like, or it looked in your questionnaire, that a former student of yours was a victim of a vehicular homicide.
Yes.
Sorry about that. Anything about, well, how long ago was that?
Early 2000s.
Anything about that experience, given, was it a child or was it a
high school student?
High school, okay. Sort of given that, and that this is also a case involving the death of a child, do you think that experience would influence your view of the evidence, your deliberations, or your verdict?
No, not in terms of like influencing it. It just, the experience helped me. I guess that gave me an opportunity to sort of see the grief of a family in that sort of scenario, but not that that would impact a decision because it's a completely different scenario.
So I want to just switch topics a little bit, and I'm going to just going to kind of go row through row. So taking us out of this courtroom, I'm talking generally in life, I think that different people have different levels of trust in the law enforcement, in the government, in the media, things like that. There's some people that are very skeptical of like the mainstream media or skeptical about what our government tells us, and others not so much. So I kind of want to find out where y'all fall on that spectrum. So I'll start with the first row, and you can just raise your paddles to this question. So if you could raise your paddle if you consider yourself like generally skeptical of the government or the mainstream media, anything along that line. Okay, and if you can just keep it up until I say, put it down. So I have juror 2, 3, 7, and 8. What about the second row? All right, so I have juror 12, juror 14, 11, 15 and 16 and 18. What about the third row? So, okay. Juror 25, okay. Fourth row?
Third row, we have number 30.
Oh, excuse me, sorry, I missed you. I see 30, thank you, deputy. All right, into the fourth row. Okay, I see jurors 31, 35, 38, and 39. Thank you. Fifth row, 42, 43, 45. Thank you.
44.
Oh, sorry, 44. Thank you. And then the sixth row. A lot of you guys. I have 51, 52, 53, 54, 55, and 57. Okay. I will ask, I'll pick on juror 18 since he's close to me. So can you just tell me a little bit about that, like why you raised your paddle?
I think that we just get so many different perspectives in the news and the media that I personally watch all different aspects of the different medias to try and formulate my own opinion.
Okay. Do you think it's important to like do your own research to figure out what really happened?
I personally do, yes.
Okay. And what about juror 35? If we could go back to juror 35. Why did you raise your paddle? Or like, what were you thinking about?
It's, it's not unusual for there to be two completely different sides that aren't even close in the media. It's the media thing. Don't worry about the government, but it's the media thing, It's not even close to being in the same ballpark of, so it's so biased.
Okay. Did anybody who raised their paddle have a different reason other than, it sounded, juror 18, juror 35 had sort of similar reasons. Did anyone who raised their paddle have a different reason than what we just heard? Okay, so juror 14, if we could get the mic to 14.
I don't want to get into it, but I don't trust this administration at all. So when you said government, it was all about the government.
Understood.
Thank you.
Okay. Anybody else want to share why they raised their paddle? Okay, wait. All right. We'll get back to that. Okay. I also just wanted to talk about another topic that and I'll just pose this to the group as a whole. So the judge talked to you about Mr. Williams' right to remain silent and to not testify. But I kind of want to flip the script and talk about hypothetically if you were to hear from Mr. Williams or the accused in a case. Because I've heard jurors sometimes say that, well, you know, if the defendant testifies, they have a stake in the case, right? They're going to say whatever they want whatever they can to save themselves. So like, I'm not gonna believe them, right? And some people feel that way. Some people don't, some people do. Does anybody agree with that, what I've heard before, what I just said, that if you were to hear from Mr. Williams, that you would just kind of toss out his testimony because he has such a big interest in the case? Okay, Chart 31, thank you. Anybody else? 25. Anyone else? Yeah, sorry, I sometimes ask confusing questions. So would you, if you were to hear from a defendant in a case, okay, would you, just because they're the defendant, they have an interest in how the case turns out, just sort of disregard what they have to say because they have such an interest in the case? It's just that if you can raise your if you.
I don't have a good opinion on that. It's kind of a confusing scenario.
Understood. Thank you for being candid. Let's see, Juror 17. I know you did not raise your paddle, but why didn't you raise your paddle?
Because I just listen to the case and try to be neutral to make my decision.
Would you expect, if you were to hear from Mr. Williams, would you expect him to have to prove his innocence through his testimony?
No.
And why not?
Again, listening to the facts. Just listening to his part of it, and then what else is being presented. And then I gather my thoughts from there.
All right. I appreciate everyone's patience with us. I know it's been a long day, but I have no further questions.
Council approach. Ladies and gentlemen, we're going to have that conference that I talked about this morning, which you cannot be present for. I anticipate the conference will last no more than 15 to 20 minutes. So I'm going to ask you to enjoy a break and come back at 4:30. During the break, no texting, tweeting, blogging, emailing, sending, or accepting messages, communications of any kind about this case or your jury service. When you come back, you don't have to sit in your assigned seats. You can sit anywhere because the jury would be identified. I'll announce who the jurors are, and I'll have some comments for you all. Enjoy your break. Two total, and then one. All right. Clear? The veneer has left. Deputies, could you take Mr. Williams over to 11B so they can have their conference and then bring them back at 4:30? Yes? Yes, ma'am. Thank you. Deputy, you needed these? Did you need that? Damien told me to give it to you. Oh, for tomorrow. Okay. Okay. I didn't know if it was today or tomorrow, but he told me to give it to you. All right. Okay. All right. Good. we have an issue. The juror contact numbers that they gave us, some of them are not working numbers. Right. So we tried to contact them two ways. They gave us an email and a phone. Mr. Williams, my judicial assistant, tried to reach some of them by phone, couldn't do that. We reached them by email, no response. So we have to have a backup plan in case they don't show. My backup plan is, it's 4 of them. If you want me to identify them for the record, I can. I'm gonna tell you by name because I don't have, it would take me too long to figure out on the, oh, I guess I could. Hold on a second. We did. We exhausted every resource. Yeah, we did. We asked the jury office, confirm the same numbers they gave us is the number that the jury office has. So it's juror 6, juror 12, juror 15, juror 34. So my plan is to have 4 extra jurors. So instead of choosing 5, we're going to choose 9. Nobody's been sworn in. So if the 4 that we are not sure about show, we can release the other 4. You all can kind of, we can figure that. It would be a good problem to have, really, is what I'm saying. So at least we would not have not enough jurors and have to go through another jury selection process if they don't show. So you can think about it kind of overnight. My inclination is to let the extra 4 jurors from today go, but we can think about that. I have to think about that because this has not happened before, at least in my experience. So we'll kind of think about it tomorrow and address it tomorrow. Theoretically, because none of them have been sworn. So right now we don't have any sworn jurors. I'm just giving you all sufficient numbers so that if some do not show, we still have 12 plus any alternates. Does that make sense?
It does. So we will each get 4 peremptories for the alternates today. I'm just trying to.
I wasn't planning on that, Miss Willis, but if we want to, Wilson, sorry. If that's a discussion that you need to have, if that's a request, then you need to make it. I'm still inclined to just give you 2 alternates, but alternate strikes. 2 additional. You still have the 2 actual juror strikes.
That's the issue.
Okay, I don't know. I've been here, so I didn't know that. I don't know what the issue could be, but I just know there are 4 jurors that we can't reach.
Yeah, I have Verizon and I have no service right
Okay. Like I said, it'll be a good problem to have if we release 4 people. 4 people will be very happy to be released tomorrow, but at least we have a backup plan. So as it relates to the actual jurors, state has 2, defense has 1. What do you want to do about the alternate? My inclination is just to give each of you 2 alternates, but I will be receptive to any requests. That's fine. 2 alternates. All right, thank you. Now, we can go back to official business. Any cause challenges, agreed upon cause challenges by the parties?
Yes. Juror 1.
Mr. Williams, do you agree to striking juror 1? Number 1.
No, this was what we're trying to. So agreeing with.
That's the lady that said she couldn't understand English.
Okay.
You agree?
Yes.
Juror 1 excused for cause by agreement. Any others? Mr. Williams, do you agree?
Yes.
Juror 2 excused for cause by agreement. Any other cause challenges?
7.
Mr.
Yes.
Williams, do you agree?
Mm-hmm.
Yes?
Yes.
Thank you. I'm going to ask you to remember to use words for me, okay?
Okay.
Juror 7 excused for cause by agreement. Any others?
27.
Mr. Williams?
I couldn't see because her hand way. Okay. Yeah.
27, do you agree?
Yes.
Juror 27, excused for cause by agreement. Any others? 29. Mr. Williams, do you agree to 29?
Yes.
29, excused for cause by agreement.
37.
Yes.
Mr. Williams, you agree with 37?
Yes.
All right. So right now, the remaining juror would be 10. Does the state agree with that juror?
Yes.
Defense?
Defense would strike juror 10.
Defense has exercised its only peremptory challenge to juror 10. The last juror is 11. State agree?
State strikes 11.
State has used its 10th, right? 10th peremptory challenge on juror 11. We're up to 14. Does the defense accept? State accept?
No, state strikes 14.
State uses its last peremptory challenge on juror 14. The panel is now at 17. Does the defense accept?
We have no further peremptory, so we accept.
State accept? All right, so the panel consists of, going back to yesterday, using yesterday's paddle map, 5, 6, 8, 12, 15, 34, 36, 39, 53, 54, 61, and 17. We've discussed 8 alternates. The alternates are 8 from the new map. The alternates are juror 21.
18.
Did I miss? Okay, let me count again. 1 second. Okay, yeah, I missed 18. Juror 18 for the alternates, 21, 32, 33, 35, 41, 48. Does the state accept the alternates? I thought I said 45. If I didn't, 45 and 48. Does the state accept the alternates?
Yes.
Defense accept the alternates? Yes, ma'am.
Defense would strike juror 32.
Defense has used its first peremptory challenge, first alternate peremptory challenge on juror 32. We're now up to 49. State accept? State has used its first peremptory challenge on which one? 21. Okay. We're now up to 50. Defense accept?
This would strike juror 45.
Defense has used its last alternate challenge on juror 45. We're up to 52. State accept? Yes. You said 18? State has used its last peremptory challenge on juror 18. We're up to 54. Defense accept?
Yes, defense accepts.
State accept?
No.
Yes. I'm going to do it right now. But what were you saying, Ms. Walensky?
So, in order, because we have 8 alternates right now.
Uh-huh.
If, let's say, all 4 of those people don't show tomorrow because they didn't get the message,
Mm-hmm.
then the first 4 alternates would take their place.
I got to do some research on that, but that's my belief. I believe that's what the law says.
Okay.
The first 4 would become the main jurors, and then the last 4 would become the
Because
alternates.
we're picking in the order that they're seated.
That's my understanding. That's my understanding of the law. I would like to be able to have that fruitful and fulsome discussion tomorrow morning. You all can do the research as well. All right, you ready? Okay. So panel consists of going to the first panel using the first panel paddles. The jurors are 5, 6, 8, 12, 15, 34, 36, 39, 53, 54, 61. Going to the second panel and 17. The alternates are 33, 35, 41, 48, 49, 50, 52, 54. Does the state accept this panel? Does the defense accept this panel?
Subject to any previous objections that may have been made, but we accept.
Okay, I don't recall any previous objections, but okay. I've
for the
already ruled
record.
on it, but I just candidly don't recall any prior objections. I think I honored any cause challenges that you wanted. Oh, there was, I do remember
It was
one.
yesterday's
Yes,
objection.
yes,
so
I remember. Okay.
Subject to that objection, we accept.
Okay.
And any other objections that may have been made.
And any who?
Any other objections that may have been made.
Thank you. Yes. Mr. Williams? Yeah. Have you participated in the jury selection process? Oh, let me put you under oath. Just turn around, raise your right hand. Let's raise your right hand, sir, please. Do you solemnly, the other right hand? It's been a long day. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yeah.
You can put your hand down, sir. Did you participate in the jury selection process?
Well, I think the state was going to get rid of 10, but my lawyers really moved too fast, and I think they was going to mutually agree to get rid of 10.
10 on which panel? The second panel from today?
Yeah, they was going to mutually agree to get rid of 10, but they moved really fast before they can do it, right?
Well, nope, the state did not move to excuse 10 for cause.
Okay.
And they did not use any peremptory on 10.
Okay then.
So now your attorneys use the peremptory on tape.
Okay.
All right?
Okay.
So I'm going to go back and ask my question. You participated in the jury selection process?
Yeah.
You actively participated in the jury selection process?
Yeah.
Satisfied with the process?
Well, I was, that was kind of weird that we lost 4 people like that, but.
Well, we may not have lost them. It's just that we can't reach them. So I just have a backup plan in place.
Oh, so if we can reach them, then they'll still be on?
Yes, sir.
Oh, okay. Well, I'm okay. I appreciate it then.
Okay. Satisfied with your attorneys?
Yeah, they seem
Right
to
now.
be doing their job, yeah.
All right. Right now you're satisfied with them?
Yeah, I mean, they got a history of telling me wrong information. That's why I be asking you. And, but yeah, I'm ready to move forward.
Okay. Have they done everything you've asked them to do so far in this case?
Yeah, it seemed to be working out. So I'll see what happens, you know.
Right. Is there anything you wanted them to do up to this point that they haven't done?
Main thing I'm worried about is presenting my case in the well, the main thing I'm worrying about is just being able to present my case and have a fair trial, and that's it mostly.
Well, we haven't presented the case, so let's just
Yeah,
pause.
yeah.
Up to this point, is there anything you wanted them to do that they haven't done?
Well, yeah, we just not in. I'm mostly worried about the defense stage is what I'm worried about. That's,
Right, but we haven't
yeah.
even gotten to the defense. We haven't even gotten to opening. I'm just talking about jury selection right now. Up to this point, is there anything you wanted your attorneys to do that they haven't done?
Yeah, everything is working well now.
Okay.
I already stated my concerns. Yeah.
Okay, and we've addressed many of those concerns, not talking about your defense case because we haven't brought that up yet, okay, right?
Yeah, things going well. I
All right.
appreciate you.
All right, sir, thank you. I appreciate you too.
Okay.
Tomorrow, 8:30, a judge has graciously offered to take my docket, but I do have some 8:15s. I'm not sure if the judge planned to come in at 8:15, so I'll handle my 8:15s, and I expect that we should be able to start at 8:30. We notified those jurors that we were able to reach to come at 8:30, and so they know to come at 8:30, and I'll notify these jurors to come at 8:30. And are we ready to bring in the jury? Yes. State. Mr. Williams, are you ready for us to bring in the jury and announce those folks that are going to be part of the panel? Yeah. All right, let's do that. You all can sit anywhere, but you just have to be seated. You can sit anywhere, but I just ask that you sit in the middle. I mean, in this middle, not on the sides. Please be seated. We have selected the jury. When I announce your name, deputy will show you to your new seats. Juror 17. Juror 33. Juror 35. Juror 41. Juror 48. Juror 49. Juror 50. Juror 52. And Juror 54. For the remainder of you that are still sitting in the hard seats, I want to thank you for your time, attention, candor, and patience throughout this process. I believe we have the best system of justice in the world. It doesn't work without willing participants willing to serve. And I thank you for that willingness. It's just 5, so I guess we should collect the badges, Deputy? Okay, so before you leave, Deputy Francis will take your badges. We will notify the jury office that you have completed your jury service with the court's deep and profound thanks. Can you tell the jury office that some of the veneer is coming down to get their parking validated? Deputy, we're going to call the jury office to let them know if they can kind of stay so some of these jurors can get their parking validated. Counsel, you all can be seated. So, ladies and gentlemen of the soon-to-be jury, we started this process a few days ago. So there are some jurors that have already been selected. So you're going to meet your colleagues tomorrow, where we will then begin the trial with swearing the jurors in, and I'll give you some initial instructions, and then the attorneys will present opening statements if they choose, and we'll start right into the evidence. I generally have a docket in the morning. A judge has graciously offered to cover my docket. So there is 8:15s, and most judges start their dockets at 8:30, so I don't want to impose that 8:15 on the judge, so I'm going to take the 8:15. So I'm going to ask you all to meet tomorrow at 8:30, where we will swear you in, I'll give you instructions, and start the trial process. Any questions? Yes, sir. Deputy Francis will show you where to go. Now that you are going to be part of the jury, you're going to walk out the back way, which is where all the judges walk, but he will tell you exactly where to meet tomorrow at 8:30. Any other questions? All right, I wish you a good night. No texting, tweeting, blogging, emailing, sending or accepting messages, communications of any kind about this case or your jury service. No discussion of this case with friends, family members, or anyone that may want to hear what you did today. You're at jury duty, and that's pretty much all you can say. No looking at social media you can look at social media, but nothing pertaining to this case. No watching news media, nothing about this case. Please make sure that you abide by these instructions so that we can have a fair and impartial trial, and I don't have to potentially have to consider whether you violated my court order. I wish you all a good night. You can give it to Deputy Francis. Thank you, sir. Yes, that's it. Counsel, you may be seated.
Can I clarify the timing? 'Cause I thought it was 9. So are they coming at 8:30 so we could start at 9? Or were you intending to start at 8:30? Because
I'd like to start as soon as possible, but if you, we told the people, yes, from when we started the process to come at 8:30, I'm telling them to start at 8:30. If there are issues, then we theoretically can start at 9, but I wanted to provide you as much trial time as I possibly could. And as I said, a judge was gracious. It could very well be that what I have at 8:15, if people are late, it may end up being closer to 9, but I'm hoping everybody is laser focused on time, and I start those 8:15s on time.
And there's also the potential, if the service comes back overnight, that we could potentially reach those other jurors in the morning too, the ones that we selected.
Like I said, Mr. Williams attempted to reach them by email and by phone. So he covered effectively all of his bases. So if we were just concerned that because we could not additionally reach them by phone, I don't believe he got any bounce backs with any emails. So we just have to hope that they're looking at their emails and or looking at their phones, which is why I did both.
Understood.
I did tell them. I just told them I wouldn't tell them the time. And I also told them that we would be in touch with them today to let them know what time to come back because we weren't sure where we are. So when we recessed, whatever day that was, I gave them all of this information. The only X factor was what time to appear.
I'm just texting my office. I'm just trying to bump everyone a half hour earlier. If there's an issue, we will let the court know.
Okay. Ms. Wilson, any issues? No. Okay. Ready to recess for the day?
Yes, please.
All right. Have a good night, everyone. See you tomorrow.